So welcome everyone to the next program in the career series here at Berkeley Law in the Berkeley Center for Law and Technology. Again, Wilson Sonsini has been kind enough to donate a few extra hours to us to go through a practice that in many ways, according to many students that have talked to me, is mysterious in terms of how does it go from classroom to day-to-day practice. Sometimes it's hard to envision what you would do day-to-day. But I think this will be a great presentation and a great explanation of what the practice looks like broadly and what the practice can look like in different types of firms with different types of clients. Because the idea of an antitrust lawyer is not a single monolithic thing. Not all antitrust lawyers do the same thing day to day. In fact, there are pretty significant variations from controversy litigation all the way over to transaction work. So it's a pretty broad field when you really start to think about it. And Wilson has its own very unique flavor of antitrust law, and that's what we'll talk about. So today we have two attorneys with us, both from Washington, D.C., Jeff Banks, a partner there in the Washington office, and Rachel Gray, an associate there in the Washington office. So thank you for joining us today and helping everyone out.
Thank you for hosting, and looking forward to help.
Well, the first thing I want to lay out there is, what is an antitrust lawyer, or what flavors do antitrust lawyers come in?
Sure. So I'll start off. Welcome, everyone. Thanks for watching. I thought I would describe kind of generally antitrust law. What does a firm look like that focuses on antitrust law, and then what does Wilson look like? So antitrust law at its core is a body of law that protects competition. It is meant to protect lower prices. It's meant to protect greater output, and it's meant to encourage innovation. And that last one is particularly important in the life sciences area that we'll talk about in a little bit. All antitrust lawyers, whether litigators, counselors, merger lawyers, transactional lawyers, et cetera, they're all focused on that aspect of antitrust law, promoting, protecting competition, and making arguments in defense of your clients in order to do so. Wilson's focus is on antitrust law. We have a 75-person or so group here at Wilson Sonsini that is 100% dedicated to antitrust. We have 4 key verticals in our group. One is transactional or merger, and they're often working with the corporate department to conduct diligence for deals and work with the agencies, the Federal Trade Commission and the Department of Justice, to try to clear those deals. A second vertical is litigation. Rachel and I are both antitrust litigators, so we'll be talking a lot about that today. A third vertical that we have is criminal law. So certain antitrust violations can be criminal in nature, and people do and can go to jail for violations, and we have certain attorneys that specialize in that area. And fourth, we have regulatory and investigations. So the 2 agencies I mentioned, the FTC and the DOJ, are extremely aggressive in terms of enforcement. Wilson is a bit unique in that many of our partners, I want to say about 15 out of 17 or so, maybe more, have government experience, either the FTC or the DOJ or a state AG's office. And being able to interface with those government agencies is very important as they conduct investigations of our clients.
So, Rachel, you're newer to the practice. With all of those options, how did you end up picking one, antitrust, and 2, the litigation side, the civil litigation side?
Yeah, that's a great question. So I got into antitrust through my 1L summer. I accepted a internship position at the Federal Trade Commission, and I really enjoyed that experience. But I will say, when I applied for the position and accepted it, I didn't really have a great idea of what antitrust was, or have a technical background, frankly. And so I think some of the law students who are thinking about their direction. I do encourage folks to be like open to new opportunities and new experiences. I found that you may have a plan, and life doesn't always follow the exact plan, and if you close yourself off to that, sometimes you're missing out on really unique opportunities. So I interned at the FTC and really enjoyed it. After that, I was then looking actively for a group with a large antitrust practice, and I really fell in love with Wilson. I think that the clients are really varied, and that is something I've appreciated over the couple of years I've worked here, that I've been able to see clients at kind of multiple stages of the development process. And I will say, as an associate, I was able to try a lot of the verticals Jeff talked about, and I think that it is pretty unique to Wilson, and can be really valuable. So I was able to do some merger work, helping conduct what they call overlap analyses, or kind of understanding where two companies may overlap in the products that they sell or may sell. I was able to work on a criminal investigation, and that was really a wonderful experience. And now a lot of what I do is litigation, both affirmative or offensive litigation and also defensive. And that, I think, also is really unique to Wilson, that I'm kind of able to wear both hats and see, both sides of the equation, as both defense counsel and plaintiff side.
So it sounds like, a lot of the areas of law you can work in these different verticals earlier on, but eventually you pick one to specialize in. Is that a fair statement, or do people move back and forth between the verticals?
It's fair for some and not for others. I happen to specialize more in litigation, so I tend to do that, although I work very closely with partners and associates who focus in other verticals. But we recently promoted one partner who frankly fits in all four verticals. And on any one day, he may get a call to help do diligence on one of our startup clients being acquired by a larger pharmaceutical company. On the same day, he likely is preparing for a court hearing for a litigation he's working on. He's regularly interacting with the FTC and DOJ, and may be as well working on a criminal investigation. So there's no hard and fast rules here. There's no, I like to say that there's no formal walls between the verticals, and people can have really good experience moving back and forth between them. Frankly, the well-rounded antitrust lawyers are better usually.
Now, is every firm that has an antitrust, first of all, not all firms have an antitrust group, but for those firms that do have an antitrust group, do they all have these verticals?
Definitely not. I think most firms that have an antitrust practice, those lawyers tend to do more than just antitrust. Often you have litigators who move back and forth between antitrust litigation on one side and non-antitrust litigation on another. It's really the top 10 to 15 practices or so that have dedicated antitrust groups, where the people in those groups are usually doing 100% antitrust like us. Even there, though, I like to think that we are one of the most diverse groups with the broadest possible practice. I don't think everyone has the experience we do. And I'd call back to what I mentioned before, the depth of experience we have with folks who have worked for the government agencies in all of these different verticals. I think it's really only a few firms that have that sort of experience.
Well, I heard you mention twice now companies in the life sciences space. So, I mean, obviously that's not a vertical that you mentioned, but it seems like an industry specialization. How does a life sciences antitrust matter vary from any other life science or any other antitrust matter?
Rachel, do you want to take that one?
Sure. So, Wilson does have a variety of clients. I think that we I don't want to say we focus we do focus, I guess, on, tech and life sciences. I think those are two of the larger practices, although, like I said, the firm has several other clients. And I think what is interesting about the life sciences space is that I guess I don't know how different it is from, say, a non-life sciences litigation, for example. But I think what I've really enjoyed about practicing in this area is like the products that are at issue, or kind of the clients that we're working with. So I'm on two affirmative litigations, and they pertain to pharmaceutical products. And there's something very it's both scientific, which I do like. I'm not a scientist, but I kind of like being science adjacent. Um, so it's scientific, but there's also very much a human element to it. At some point, everyone is going to need a medication or need some kind of medical device. And I think that I really appreciate that element of the practice. It's something that really resonated with me and with my brain. Truthfully, it kind of clicked in a way that sometimes other product markets or other products that you're working with don't always register. Yeah, and so I found it very rewarding. And as someone who at one point, entertained the idea of going to medical school, I didn't, but of course. But yeah, I think it's sort of nice to stay adjacent to that area and stay engaged as a lawyer.
One thing I'll add, so as Rachel mentioned, Wilson's pillars typically have been tech and life sciences. And the way that our firm grew was we started with lots of little startup clients. And as those startup clients grew, as they got more and more funding, some were able to go through the IPO process. They became public companies. Their problems grew. And as some of them became really leaders in their industry, they started to have antitrust problems. And so that was the way that our antitrust group grew. It was alongside of our clients as they started to have new, novel problems. As they grew, our group grew their capabilities as well. And I think life sciences is particularly a good example of that. We have obviously as our clients some of the largest pharmaceuticals and life sciences companies in the world, but we also have a lot of startups, biotech clients, small one or two founder companies, really just on the precipice of beginning their journey through that corporate process. And from an antitrust perspective, I'm able to help all of them throughout that entire stage. Throughout that entire process, I mean, at each stage. Of course, we're defending some of the largest pharmaceutical companies in the world in litigation. We're also, as Rachel mentioned, on the plaintiff side of a lot of litigation on behalf of those clients. For the smaller companies, though, there's a lot of antitrust work that we're able to do for them, more around counseling and compliance as they get ready to move through the ranks of that corporate process.
Well, you mentioned something that caught my attention earlier about some attorneys and some firms that do antitrust work. They also do commercial litigation. They're not dedicated antitrust lawyers. So, if you poke around websites, a lot of firms say they have an antitrust practice. And then when you look at the representative matters, there's one antitrust case, about 7 down. And I'm going to say I might have been one of those people. Patent litigation, every once in a while, patent litigation becomes an antitrust litigation. And I would always just hope that it didn't go very far. So how do people understand that this difference between a dedicated practice and this word sounds terrible, but I think it's appropriate, in dabblers?
From my perspective, I think it's an intentional decision that people make when they come to Wilson Sonsini. We're very open and public about our practice here. And when you come to work for Wilson Sonsini Antitrust, you are committing to antitrust. But I don't see that as narrowing your practice. In fact, I see it as a way to broaden the practice because no offense to the commercial litigators, but often they come in for a breach of contract case or maybe a securities litigation, usually on a narrow issue. When you're an antitrust attorney, you have to understand not just the issue that's in front of you for the business, but also the entire business. How does your client compete? Who do they compete against? What does the industry look like? What does the market look like? Who are they buying from? Who are they selling to? Who are their customers selling to? And so to me, committing to antitrust has actually been kind of a way to open up my practice as I learn more about the entire life sciences industry or tech or lots of other industries that my practice has touched upon.
That's a really interesting perspective, that just the very nature of antitrust is you have to be deeply integrated with your client's business and that marketplace. And a breach of contract, those types of cases, you don't really need to necessarily know much more than what's in your document. I mean, they could still be worth hundreds of millions of dollars.
Absolutely.
But it's not how it plugs into the entire market that makes a difference. So is it this type of, I guess, this type of embedded relationship that really helps you long-term kind of work with the same client over and over? Or is this, do you just work for a client and then finish the case and move on?
No, with many of our clients, it is a multi-year relationship, multi-matter relationship. Rachel, maybe you can give some examples of some of the work that we've done for some of our major life sciences companies in particular. Just generally thinking about how you look at a marketplace and understand the nature of the problems that a client might face.
Yeah, absolutely. And I completely echo what Jeff said as far as choosing antitrust kind of broadened my practice. I was definitely someone who was worried, about cutting off opportunities at certain decision points. And I will say that antitrust has been great for me because I get to kind of develop an understanding and expertise of the law, but then can kind of apply it in so many different ways that it just keeps my practice interesting, but also I don't feel, I feel like it has completely helped me actually. And I think going into the practice, I don't know if I would have seen that as an outcome, but I think that's something to keep in mind, that it really allows you to be flexible in how you're using the law, but it allows you to develop like the confidence and an expertise in the law and understanding kind of the outer bounds of that. And that has just been really fun. And yeah, I tend to work a lot with one of our larger clients, and I think that has our larger life sciences clients, and that has been really rewarding because they have all sorts of questions and things that they're interested in, and I've kind of been able to work with same in-house counsel for several years, and I think that has been really unique. And I think I've been able to develop a relationship with them that kind of gives me comfort and ownership over my own work in a way that lets me feel confident as a fourth year student, running or it's not student, sorry, fourth year associate, being engaged in litigation. So I'm happy to talk about the cases I'm involved in if that would be of interest, but generally, it's been really rewarding.
Well, I think it would be helpful for the students at least to know generically the type of matter they could expect, because you know what an antitrust class looks like in law school. And again, it's just hard to go from the classroom seat to envisioning what you might be doing for years of your career. So it'd be great to have some ideas on specific matters, and especially in this life sciences space, because that's a space that I promise you doesn't show up in many of the textbooks. So completely mysterious.
Yeah, right. I don't recall reading a life sciences case in law school, at least with regards to antitrust. But so the two affirmative litigations that I'm working on are generally about trying to. We basically allege that our client was foreclosed as a generic from entering the market through a variety of practices. Obviously, generics provide a huge cost saving for the healthcare sector. They're great for patients, and they really are I think, an incredibly important part of U.S. healthcare system. And we have regulatory regimes in place to help facilitate the entry and development of generics. So that those two cases have been really interesting, and I think I've been able to be a part of them kind of since their incipiency, or at least pretty early on. And what's been really fun and interesting about that is just thinking about the case, thinking about the issues we need to be aware of, things that we may, just at a high level, kind of thinking about strategy and where we want to be down the line. So it's been really interesting. I mean, I think Wilson has been really unique, and the fact that I've been able to have those opportunities so early on in my career. I think I am not unique, though, in that respect. I think the firm does a great job at giving young associates a lot of experience, a lot of responsibility, and that really is the only way to grow. And I've really appreciated it.
So looking kind of at the horizon for students graduating, I can say over my career, which has been slightly longer than yours, Rachel. I'm judging from the bald head. You would probably figure that out. There were, at the beginning of my career, antitrust was slow. Not one of the big places where people were going. But it seems like over the last several years, maybe the last decade, antitrust has really risen to be one of the most important areas in the transactional world, the litigation world. And judging from what I read in the Times and the Washington Post and the Wall Street Journal, this seems to be a rapidly growing area that's going to be, for better or worse, pretty prominent for the next couple decades. Am I misreading that? If I was a student, is that a fair reading?
No, that's a fair reading. And if you're looking for a hot area to go into, antitrust certainly is one of them. I think it's been increasing in prominence, probably a little bit more than you might think over the last 15 to 20 years, although with the media attention, with the administration's attention to antitrust, and with the agencies enforcing antitrust perhaps a little more aggressively than they have in the past, the last few years certainly has been a good time to be an antitrust lawyer. I don't see that changing anytime soon, regardless of any change in administration. I think companies are really focused on antitrust compliance. They're focused on antitrust problems and solving those problems. And plaintiffs' attorneys, of which we are plaintiffs' attorneys sometimes, are really focused on ways to bring antitrust claims to further their clients' business interests. And that's inside of life sciences, it's in tech, it's everywhere. In the non-life sciences arena, I'm representing a company right now in the real page litigation. This is extraordinarily cutting edge. The allegations are that a number of landlords use the same third-party software, which has an AI component to it. And through that AI component, they are sharing competitively sensitive data and committing an antitrust violation. That's the allegation. It's something that the agencies are focused on, federal and state governments are focused on it, the plaintiffs' attorneys are focused on it. It's a fun area to be involved in. So both within life sciences and outside life sciences, I expect antitrust to continue to remain hot.
That's actually a great piece to bring to that. If you read the case books, the antitrust case books, it's two people having lunch, colluding to fix prices. Very old school. What you're pointing to is people don't need to get together anymore. Technology is potentially a game changer on these types of things in terms of ways to communicate. So that's the exciting piece that doesn't make it into the case books, that makes it into the day-to-day practice. So.
Right. And we do a little bit of both. One of my other cases is on behalf of a very large generics company. They are alleged to have fixed prices with the other generics manufacturers. The case has been going on for many, many years. The state attorneys general who are leading the way in the litigation have called it the largest alleged conspiracy they've ever seen. Of course, I added the word alleged. But we're defending that more traditional price fixing case there, defending this AI-based case in other areas, and I expect that the allegations and the claims in these types of cases to continue to evolve as technology does as well.
And you pointed out, and I think it's worth noting here, is that administration changes probably aren't going to be impactful here, because antitrust has gotten everybody's attention in the last decade, 15 years, where, again, the case books often show it as a political issue from years past. This is a hot issue, and everybody's interested in it. Like you said, from the plaintiff side lawyers to state attorney generals to regulatory agencies in Washington. And that's a lot of attention, which means a lot of legal work.
Yes, absolutely. And I expect that to continue. It's rare for the left and the right to agree on anything, but if you look at the way that antitrust has been enforced over the last 8 years, I don't think it's really mattered who was in the seat. Everybody wanted to go after tech, and life sciences is always right behind it. So I think the political division that you might have expected 20, 30 years ago in antitrust is probably gone, if not for good, for a very long time.
Well, wonderful. I want to thank you both for taking some time today to get people started to looking at this as a career path. I suspect you'll get some follow-up questions from some students around the country as they start to see this as a pretty interesting path going forward, whether they're technology, I love your word, Rachel, technology adjacent, you want to be in the middle of the technology, or you like a good old-fashioned criminal case with price fixing. It all seems to be here in this kind of group that you have structured. So a very, very interesting discussion, and I really thank you for taking time out of your busy schedule.
Thank you very much, Wayne.
Thanks.